Welcome to our virtual roundtable on recent federal immigration policy developments and what they mean for Maryland's employers and our workforce. I am Mary Kane. I'm the President and CEO of the Maryland Chamber of Commerce, and we're glad to have so many of you joining us for this very timely conversation early this morning. We appreciate our partnership with the Governor's Office in making today's program possible, and we're grateful for their commitment to help Maryland businesses navigate rapidly evolving federal policies. While immigration policy is primarily driven at the federal level, the operational impacts are very real to Maryland employers, from compliance requirements to workforce availability. And today's discussion is designed to offer clarity and practical guidance at a moment when many businesses are seeking it. We're honored to be joined by Delegate Adrian Boafo, Kamal Esahib, who is the Senior Advisor and Director of Immigrant Affairs at the Governor's Office of Community Initiatives, Kelly Deaning, and Jason Barrett from partners at Berry, Applebaum, and Leiden. But before we begin, a few quick notes. Please use the question and answer function to submit questions at any time. Delegate Boafo will open with brief remarks, and then Kamal Esahib will talk about the Moore administration's efforts to tackle immigration reform, followed by Kelly and Jason, who will discuss the most pressing issues and review what employers should be looking out for. Then, if time allows, we will close with some audience Q&A. And just to let you know, this webinar is being recorded and will be shared with all the registrants later this week. And with that, Delegate Boafo, welcome back to Annapolis for your special session. Thank you for joining us, and the floor is yours.
Well, thank you, Mary. It's an early morning here in Annapolis, but truly appreciate the Maryland Chamber of Commerce for doing this. In Maryland, our diversity is rich, and our immigrant population is about 22% of the workforce here in the state. And so it's critically important that employers, as well as employees, understand what's happening in this ever-changing landscape. I also would be remiss if I didn't shout out Kamal and the Governor's Office. The second floor has been a tremendous partner to all of us here in the General Assembly as we navigate what are tough times at the federal level. Now, as somebody who hopes to be at the federal level fairly shortly, I will say I do hope one day that there is an effort in a bipartisan manner to make sure that immigration reform is comprehensive. And that's critically important because, frankly, people do not see the economic side of what happens in times of uncertainty like these. So again, shout out to the Maryland Chamber of Commerce for getting this done. The one thing I did want to highlight this morning is really how critically important, again, our foreign-born residents are to Maryland's workforce. Maryland's unique. We sit right in the middle of DC, accessible by train to Pennsylvania and New York. And so we are truly an economic hub in a traveling region. And about 1 million folks here in our state are actually who are in the workforce are actually foreign-born. But some specific numbers that I think are really critical to kind of highlight this morning: 22.7% of workers who are in the healthcare space, 17.8% who are in business or in science fields, 12% of whom are in the construction industry. And so as we kind of continue to navigate through these tough times, we know how important it is for employers in this moment to try to fill in their worker gaps by hiring the most qualified and talented people they can find out there, oftentimes those who are immigrants and those of the immigrant community. So, Mary, this is such an important discussion. I wanted to come on this morning and just salute the Maryland Chamber of Commerce for trying to steer our business owners and our employers in the right direction. So God bless y'all, and thank you for having me this morning.
Oh, Delegate Boafo, thank you very much. As the daughter of immigrants, I really appreciate you taking the time to do this, and for Governor Moore to be very involved in this whole issue. So now I'm pleased to turn it over to Kamal Esahib from the Governor's Office. Kamal?
All right, thank you, Mary. Thank you to our partners at the Chamber for organizing this. You'll hear more about the immigration policy changes from Jason and Kelly. But I know we are already starting to see their economic impacts. And it's not surprising that federal immigration changes would have an economic impact. You heard the stats from Delegate Boafo, but just to add a couple more, half our country's, Fortune 500 companies were founded by immigrants or children of immigrants, right? So, this issue of immigration has a clear and direct impact on our economy. And it is why the governor hosted a roundtable with business leaders in June alongside Mary and our partners at the Maryland Chamber of Commerce. And really, we were really proud at that event to announce, the partnership with Barry Appelman and Leiden, and you'll hear more about it later. But one of the things that, we heard loud and clear at that roundtable, and the governor heard loud and clear at that roundtable, is that states need to have a role they need to have a seat at the table when it comes to federal immigration policy. And so this is part of why I'm, really excited to share that, this past weekend, as part of the National Governors Association annual meetings, during which, by the way, our Governor Moore, ascended to chair of the National Governors Association. There was, a really exciting announcement, a bipartisan announcement, to form a task force within NGA to tackle, to develop really a view, a position on what immigration reform is from a state's perspective, and really at the core of that is ensuring that immigration changes consider the impact on states, particularly the economic impact on states. So I'll drop the article in the chat, that I think reflected this announcement, and we're happy to answer any questions about it or engage further with folks on this call. But I think it's a really important step in the direction of really common sense reform that acknowledges the various impacts that federal immigration policy has. So with that, I'll hand it back to you, Mary, and I'll stick around in case there are any questions.
Well, thank you very much, Kamal. We really appreciate your insights and for you being here. And folks, take a look at that article in the chat. I know he's going to put it up there. Now I'm going to turn it over to Kelly and Jason, the actual legal experts who are going to tell us what's going on now in the U.S. and immigration. So Kelly, Jason, the floor is yours.
Great. Thank you very much, Mary. And thanks to everybody for inviting us and for joining today. As has been mentioned by the folks on this call, immigration really is an important issue and one that's really in flux, as you're going to hear from Kelly and I today. A lot of changes, a lot of impacts to your business, and it really takes being nimble, engaging with appropriate experts to kind of help you navigate what are really choppy waters and which can change very, very quickly. Great. Well, yeah, so we're here again today to talk to you a bit about how federal immigration policies are going to affect your business in 2026 and potentially beyond. And so with that, I will turn it over to Kelly.
Great. Thank you, Jason. So if you want to go to the next slide, yeah, really happy to be here today. And I think the first thing we wanted to jump off with is just first kind of really concentrating on what your rights and obligations are as an employer under a lot of these evolving regulations. So as we've all been talking about, and I'm sure many of you have been seeing, the immigration rules here in the US are continuing to evolve. And many times it's very rapidly changing, right? I think many of us are feeling these rapid changes, and oftentimes you're not getting any prior notice of these changes. You may be finding out on a Friday afternoon and they're becoming effective within 24 hours, or sometimes they're being effective immediately. And so really, I want to take this first kind of opportunity to talk about that balance that you all must be feeling about maintaining that compliance with immigration laws, but also ensuring fair treatment of your workers, right? And so there's sort of that push and pull that I think we're seeing in these evolving changes. So, whether that's requirements varying by visa category or some of the several kind of employment-based obligations that some of these immigration programs require. So we just kind of wanted to walk you through a couple practical steps on this front end of things for y'all to keep thinking about. And one of them, and I know many of you, and I know we've talked about these on these webinars now over the course of the past couple of months, is making sure that you're conducting those immigration compliance audits. And I think the most visible one for most of you are ensuring that I-9, the Form I-9 process, that you've got a process in place that follows the requirements of under the federal law. And so really making sure that when you have your new hires, you're onboarding them within 3 business days of their first day of work for pay. And then if you have any foreign workers or anyone that does require continuing work authorization to be shown, that you're meeting those re-verification deadlines, right? That you're re-verifying their work authorization prior to the expiration of their current work authorization on file. We'll talk a little bit more in some other slides about how difficult that has been for many of you, right? Like understanding the changes in TPS and other types of immigration benefits and being able to keep up with when is this person authorized to work, when are they not authorized to work, and we'll talk through that a little bit. But really making sure that you understand you've got a system in place so that you're able to keep up and completing that timely. If you do also sponsor like H-1B workers or other workers, making sure, especially for your H-1B workers, one of the big things we're seeing is more folks requesting to see what is called the public access files, or an acronym is the PAF files. Making sure that you've looked at that. I've been working with a lot of clients now where in the past, you've not really had the public asking to see those PAF files. And we are starting to see more of a trend. So making sure that you have those PAF files available for the public to review, making sure you're going to decide, are you going to provide them in a paper environment? Are you going to provide them in an electronic environment? And what does that look like for your business? How is this, person from the public going to be able? Are you going to have a reading room where they can come in and look at the ones that they're requesting? Will you give them access to your online system? So a lot of these things we haven't had to think about. So if you do have those H-1B workers, please make sure you're thinking about that compliance requirement and you're ready for if and when somebody from the public would request that. And then I know the state of Maryland does not require employers who conduct business in the state to mandatorily use E-Verify. But if you have employees outside of Maryland, if you're larger than just the state of Maryland, understand that there are several states now that are requiring E-Verify for your employees that work in that state. So like Florida, Georgia, North Carolina, there's lots of states now that are looking at E-Verify, and they're starting to require E-Verify to become mandatory. And we're seeing states now jump into that, as well as enforcing that E-Verify requirement. So we're seeing a lot of what we call E-Verify audits from those states, where they're reaching out to the employer and saying, we want to see all the E-Verify submissions for the employees that work in that state. So I like to raise that because I think that's something new that I certainly, while those laws may have been on the books, they're fairly new in terms of that enforcement. So another area, if you do use foreign workers, is making sure that if you're reviewing those remote work policies, any kind of compensation changes, work site changes, right? If they're moving amongst offices, a lot of visas are tied to those job descriptions, specific salaries, specific work site locations. So making sure that, if you have a worker that's, moving to a remote status, or if they're modifying their job duties in any way, you're giving them a promotion and that might change their salary. Under some of these immigration employment-based visa types, those are considered what we call material changes. And you're going to have to report those to the government in order for those changes to become effective and to allow that person to remain on that visa. So again, it was, the obligation's always been there, but making sure that you understand that and you're being even more vigilant now to ensure that you're making those changes before the employee moves into those positions so that you're remaining compliant and the government can see that you're remaining compliant in those changes. And then I think really the big thing is making sure that your HR staff, your hiring managers, they're really understanding these changes and they're getting trained on these obligations because we're seeing, balancing these changes and these obligations that you are required to maintain, balancing that with the immigrant and employee rights section of the Department of Justice, who is also looking at making sure employers are not doing anything to affect the employees' rights as well. And so, for example, for your I-9 program, making sure that when you're verifying documents, that the employee is the one who chooses which document they provide for their I-9 obligations, right? You're not telling the employee which document to provide, right? If they're a lawful permanent resident, you cannot require that they only give you their green card. You do have to allow them to provide whatever document they have from the list of acceptable documents that shows that they are that lawful permanent resident who's authorized to work. So just keep that in mind in these times that, that requirement is still very important. Making sure that, as we'll go through some of these changes, EAD extensions have been shortened. You used to be able to get these automatic extensions for some of your foreign nationals where they had applied to renew their employment authorization document. And while they were waiting, they would be able to work through these extensions. Many of those, other than the STEM OPT extension, all of them are now gone. And so as your employees are starting to renew their documents, just understand that it's going to be very important to track when their work authorization end date happens and that they must be re-verified by those timeframes, but understanding that there's now these gaps that may come if USCIS cannot adjudicate their cases in a timely manner. So in addition to no longer having those automatic extensions, we are seeing that the government is also shortening the time periods that they're putting on the employment authorization documents. So it used to be 2 years or 5 years that EAD would be valid. And we're now seeing that being shrunk to only 1 year. So every year that foreign national who works on that EAD card is going to have to renew that EAD card. So again, with processing times at USCIS extending, we're anticipating employers seeing possible gaps in between the time frame that their work authorization EAD card expires with when USCIS is able to actually get that new one adjudicated and out to your employee. So again, just really making sure that everybody is trained on these changes. They're looking for them. They're anticipating them. And then, of course, making sure that if those work authorization documents do expire, that you're giving that employee the opportunity to provide continuing work authorization. You don't just terminate them or put them on unpaid leave right away. You must allow them the opportunity to give you other work authorization. If they don't, or they don't have it, then you're allowed to take further action. But just know that, it shouldn't go right to immediate termination. So especially, and again, we're going to jump into this next with the TPS changes and the changes in humanitarian. With a lot of these programs ending, just be aware you should not be moving immediately to termination for these folks, but giving them that opportunity to say, I do have other work authorization. If they don't, that's then where you can take action, but making sure that you give them that opportunity. So tracking and understanding a lot of these changes are really, really important so that you understand what your rights are, what the obligations are, but then also balancing that with your employees and making sure that you're not doing anything that violates their rights either. So Jason, with that, I'll turn it over to you for the next slide.
Great. Thanks, Kelly. And Kelly touched on this towards the end there about TPS. Certainly, to say that TPS and other parole and work authorizations are in flux would be an understatement, to say the least, as I'm sure many of you are aware who have folks that work for you who rely on TPS and similar work authorization programs. It is an ever-changing environment. Seemingly, I know at least in the immigration world, we kind of rue Friday afternoons because we believe that's kind of when the next update drops and something changes. So these programs do remain in flux. They're subject both to policy actions and ongoing litigation, which makes it really difficult as an employer to track. The TPS programs, many of which I'm sure you're aware of for individuals from countries such as Haiti, Honduras, Syria. There are a number of different programs, all of which have different timing mechanisms. All of them are subject to, or many of which are subject to different pieces of litigation. And so, again, really difficult to track. As I'm sure many of you are aware, somewhat recently, the Supreme Court ruled that these TPS programs are not subject to judicial review from a non-constitutional standpoint, which really left open the Department of Homeland Security's ability to terminate these programs. And that's where you started to see the programs that had been in place for decades in some instances really come into question, and where you started to see notifications that these programs were terminating. What makes this even more difficult to track is then, notwithstanding the Supreme Court's ruling, there's still ongoing litigation. So a lot of the decisions are then sent back down to circuit courts, where now they are making decisions around particularized ability to keep these programs in place, or are they really subject to termination? And so that really makes it difficult to track from a work authorization standpoint, because a lot of ways that the Department of Homeland Security, through United States Citizenship and Immigration Services, or USCIS, they post on their website, usually on Friday afternoons, as I mentioned, whether or not something has been extended and for how long. So, for example, over the last several weeks for Haiti, we've seen situations where July 1st, there was a post, and then there was a post a couple of weeks later extending for another week or two, and then a post again saying now it's extended for a couple more weeks. So just, again, an influx area. This is also true of some other programs, some parole programs. In particular, the parole program that has been in place for the Ukraine is subject to review and depending on when certain applications have been filed. So really, again, a lot moving in this space. So practical steps. We want to be able to provide you all with just some ideas of what to do in this time of flux. I think most importantly, verify current status through USCIS notices and applicable court orders before doing anything, just like Kelly mentioned. It's really important to make sure you have the facts straight, the current state of the law, and what litigation may have done to that state of the law before taking any adverse action. I know I've personally had situations where someone who is in TPS status may have their own attorney. I've seen situations where an employer reports that, well, so-and-so's attorney told me that this has been extended, and so they're allowed to work. And that may or may not be true. But it's important for you all as the employers, to verify that information, to verify what is accurate, which admittedly can be very difficult to do, but really staying on top of USCIS notices and applicable court orders. I will say the Immigration Service, they do a lot, they process a lot. They are actually usually, and sometimes it's last minute, sometimes it's that Friday afternoon, but they do tend to post practical steps for employers on their website. They do try to really get information out to the public about the status of these TPS programs. So I would suggest, relying on that USCIS website, signing up for alerts if you haven't already, to receive alerts from them about things as they are updating. It's important to review employment authorization documents and any automatic extension notices. So again, just referring back to Kelly's comments, to really review the documents that the employee has presented, and also any notices that indicate that the extension is automatically extended, that there's an automatic extension of that work authorization. Many times in immigration, and it makes it very difficult as an employer, but a document that appears expired on its face will continue to serve as evidence of work authorization with an associated receipt or with an associated publication in the Federal Register. Things that are counterintuitive. I think we all look at a document and see an expiration date and say, well, it's expired. I need to see something else. Unfortunately, it's not that simple. So really reviewing the documents that the employee presents, seeing if there are any automatic extensions. Sometimes it is stated in the receipt notice that an employee may present. Sometimes it's not, which again does make it quite difficult. I'll reinforce here to Kelly's point, not to ask for specific documents. Just because someone has presented TPS related documents, let's say along the way to verify employment authorization, doesn't mean that's what they're going to present when you go to re-verify their work authorization. Someone may have become a permanent resident or a green card holder, now have a green card, and so they're going to present a different document. Lots of different possible scenarios here. But it is important to just, provide the list of documents and ask the employee to present whatever they feel would be appropriate. Also important, if it's an employee that perhaps does have an expiring work authorization, and this often happens, it's a key contributor to the team, to the business, you want to keep them longer term. Consider other alternatives other than a parole program, other than TPS. There can be, and they are limited, but there can be other options, different employment sponsored programs that the person may be eligible for. Many of them have, their own risks and challenges, and may require international travel or other different, considerations. But don't just say, okay, well, TPS is expired. There are no other options. There may be other options to pursue as you try to, maintain and keep that talent. And probably goes without saying, but monitor this closely. It is going to continue to evolve. We are going to continue to see challenges through litigation. I think we're going to continue to probably see the Department of Homeland Security look to terminate these TPS programs and keep that effort and that force moving forward. So important to monitor those developments closely. Sign up for those alerts. Connect with if you do have outside immigration counsel, be in touch with your outside immigration counsel regularly, so you can remain on top of what, again, is a very rapidly evolving area. With that, I'm going to turn it back over to Kelly.
Great, thanks. So then that brings us to these critical changes that we're seeing to both the compliance and enforcement that is impacting your employees. And so, again, we're seeing so many changes in the policy and things, but I think as we've been talking about and in previous webinars, we're also seeing that change in the enforcement and the way that enforcement of immigration law under this current administration is shifting significantly since 2025. So again, greater compliance, greater workforce risks, across various industries. And so again, just kind of making sure that you're following these various developments and ensuring that you're understanding the changes that are going on so that you can properly talk to your employees about these changes to help them make choices, or if that's going to be affecting your business, you understand what choices need to be made, or can be prepared and be ready. And I know in a lot of the other webinars that we've talked about or that we've presented on, we've talked about these increased worksite enforcement processes, right? or the increased I-9 audits. So again, being aware that that is happening, right? They're coming to your businesses, making sure that you're asking for that, judicial warrant versus the administrative warrant. If it's an I-9 audit, making sure you're looking for that notice of inspection. You are not waiving the 3 days to provide them those I-9s, right? Please do never waive the 3 days. They will ask you and say no. So making sure that you keep those 72 hours, because you're going to need that to collect all the documents, make copies of those documents before you turn over your I-9s and supporting documents to Immigration and Customs Enforcement for them to do any I-9 audit. So just keeping those things in mind as we see this increase. We've also anticipate seeing higher penalties for I-9 violations. So there was a memo that was issued earlier this year by Immigration and Customs Enforcement that made what used to be many violations that you would make on the I-9 form. They were used to be technical violations. They've now made them substantive violations. And what that means is historically, if it was a technical violation in any I-9 audit, ICE would allow you 10 days to make corrections to your Form I-9 if they deemed that error to be a technical violation. Now that they've made them substantive violations, you no longer have the ability to make those corrections. So if it's a substantive violation, it's an error. Like, you will be fined for it and there's no way to correct it. The only thing you can do is conduct an audit so that you highlight that substantive error, and then you can correct it, which is what we call mitigating any further error down the road. And so with that change can come significant increases in the cost that it may bring to your business if ICE comes in and does an audit and then finds all of these substantive errors on your Form I-9s. So again, long story being, making sure you're aware of this, making sure you're doing those internal audits, or you have a quality assurance process in your everyday I-9 processes to ensure that you're not making the mistakes, so that down the road, you don't have those substantive violations that ICE would be looking for. And I think the other big area that we've seen in the last year and a half is greater data sharing amongst the federal government agencies. So we're seeing a lot of the federal agencies expanding their information sharing arrangements, and then that gives the enforcement, ICE and CBP, a lot broader access to employer or employment records. And we've seen them, when they share that information, that's then when we see them going out and utilizing that information to conduct enforcement opportunities. And I think the biggest example of that is what we just saw last week in early, about a week and a half ago, where we started seeing Immigration and Customs Enforcement, ICE, going out and working with the Transportation Security Administration, TSA, and they were sharing information about domestic travel and people who were traveling domestically who may have overstayed their visa or were here unlawfully or who have orders of deportation. So they were sharing this information basically to, then get a tip where TSA would say, hey, ICE, here's the list of people that we have that are going to be flying domestically, and therefore, you do what you will. And then we saw ICE come out and make arrests at several, I think there were at least 15 airports where we saw that ICE came out and were making these arrests of people who, in one database, basically showed that they had either overstayed their visa or had some other violation. And so again, this just kind of highlights how this data sharing and how we believe they're going to continue to increase these enforcement actions through the sharing of data. And so I think one lessons learned, though, with all of this and what we were seeing as all the news reports came out, one thing that we just kind of want to cover real quickly is understanding that difference between somebody who is lawfully maintaining their immigration status versus being here in a period of authorized stay. And that was sort of where we saw a lot of angst in these airport arrests, the domestic airport arrests, were because many of these folks may have had an I-94 that had expired, right? Their immigration status may have expired. But on the other hand, they had pending applications with U.S. Citizenship and Immigration Services. So they were allowed to be here because they were still in a lawful period of stay. And sometimes that allows them even to continue to work, as Jason said, even though it looks like their document may be expired. If they have something pending with USCIS, there are certain categories where they are allowed to stay in the United States and even continue to work. And so for whatever reason, ICE was not comparing that database with USCIS. They were just looking at what their current immigration status was, and if they were overstayed or if that status appeared to be in violation, they were just going on and making those arrests, even though technically many of these people were here with pending applications, like an adjustment of status application or an extension of status of their current work author, of their current status. And so again, we in the public, or you as an employer, may be looking at that employee that may have gotten caught in all of this, saying, well, wait a minute, they were here and they were allowed to stay. I don't understand why ICE is taking them into custody. So, I think we're going to continue to see sort of what I like to say, sometimes the right hand and the left hand not always working together when they're sharing this data. And so really making sure, I think best practices kind of takeaways are, really making sure that, you're working with your employees or understanding, where they're at, looking at what type of things you can do to help support them, right? If they get caught up in these situations, what is it that you want to do to support them? And again, don't jump too quickly. As we've been saying, a lot of times, in the news, what's being reported isn't necessarily always, I wouldn't say it's not that it's not accurate, but, making sure you have that trusted immigration counsel, or you have the trusted, counsel or immigration expert that you can go to so that you can ensure that you're getting the right information, understand what is going on so that you know how to support your workforce in these situations. So really just kind of being prepared and ready for this increased enforcement, data sharing, social media, all of this will continue. And, we'll just have to keep monitoring and making sure that you all understand what's going on with these changes and how you can continue to ensure that you're supporting your workforce. And Jason, with that, I'll turn it back over to you because I know we're running down and we want to make sure we have enough time for some Q&A.
Great, thanks, Kelly. Yeah, so this is where I pull out the crystal ball and try to provide some information about what to anticipate in 2026. I think, perhaps obviously from all of the comments that Kelly and I have made, this is going to continue to change. They're going to continue to be, it's going to continue to be in flux. It's going to be a situation that has to be monitored. I think that kind of goes without saying. So to Kelly's point, and to my point of mine recently, sign up for those alerts from the government, from a trusted immigration firm, be in touch with your immigration counsel, monitor the news, not so much necessarily for what the news says, to Kelly's point, but just to be alert that something's happening, and then engage those trusted advisors as to get to the facts. In the employment-based immigration space, there's going to be likely a number of different programs that may be impacted by changes. We won't be able to get into full depth on all of those today because, like Kelly said, we do want to leave some time for Q&A. The government did relatively recently release a regulatory agenda that gave us a bit of a roadmap of what they anticipate or what they plan to do in the immigration space. And so we've pulled out a few here that are noteworthy because of their breadth and potential impact. For those of you who do use H-1B or rely on the H-1B worker program, that is just high-level overview. The H-1B is for individuals who fill specialty occupations. So a role that requires at least a bachelor's degree or the equivalent. It's subject to an annual lottery process, which in and of itself just changed this past year with a different way that workers are selected in this lottery program. That in and of itself was a big change. But looking forward, the H-1B program does seem to be one that the administration is looking to make tweaks and make changes to ensure, in particular, wage compliance. Most of the changes that we're seeing and that are on the horizon tend to be aimed, not surprisingly, at protecting U.S. workers. And so wage compliance is one where we're going to likely see some changes. By that, I mean ensuring that H-1B or trying to ensure that H-1B workers are not undercutting the wages of U.S. workers. So there's some rulemaking in place about changing how what's called the prevailing wage is calculated as part of this H-1B program, the H-1B process. There's what's called a labor condition application filed with the Department of Labor. And in that application, you have to demonstrate that the H-1B foreign worker will be paid at least the prevailing wage. And Kelly mentioned the public access file. These are all interrelated in terms of compliance and record keeping. But there's different ways that the government will change how that prevailing wage is calculated. And frankly, based on the most recent rulemaking, it's going to increase significantly. So if you do have H-1B workers and the rule does come to fruition in its at least current or near current form, you can anticipate that those prevailing wages are going to be increased. They're going to continue to look at worker placement practices. By that, we mean third-party placement. So if you have a consulting business, or let's just say you do place your H-1B workers at other work sites other than your own, we're going to continue to see compliance checks. Oftentimes, it's conducted by what's called the Fraud Detection and National Security Unit, or FDNS of USCIS, where they conduct site visits. And so I think we're going to continue to see those sort of site visits. There's also a lot in the news about the H-1B proclamation. I'm sure you've seen reports of the $100,000 fee, because that certainly captures headlines. As to my previous comments about TPS, this H-1B proclamation $100,000 fee is subject to litigation and continues to be sort of in force and out of force. Right now, it is not in force, but that's going to continue to evolve, and we're going to likely see the government, again, push for that proclamation fee to remain in place. In terms of the PERM program, for those of you who sponsor foreign workers for employment-based permanent residence or green cards, the traditional first step of that process is called a PERM labor certification. It is a test of the labor market. So the idea of the exercise is to test the U.S. labor market to determine if a qualified and willing U.S. worker is available to perform the role in the particular geographic location. And if not, then the foreign worker can proceed with their green card process. The PERM program, this labor certification program, hasn't been reformed in any real way since about 2004, 2005. And so as you might imagine, as the world has evolved, how employers recruit for talent has evolved. The regulations have not, though. So just by way of example, in this PERM labor certification at present, one of the required forms of recruitment is placing the ad in 2 Sunday newspapers, hard copy edition, the one that you pick up at the corner bodega. We are likely to see changes to that program because that's no longer how recruitment really takes place in the real world. But there are real practical implications for the PERM labor certification program to changing recruitment, all towards the eye of protecting U.S. workers. So we do anticipate rulemaking and looking for the government to change this program, in particular, really revamping how one goes about recruiting in the labor certification process. And then just going back to that prevailing wage, there is also a prevailing wage component to this PERM program and to the green card process through the PERM program. And so again, we anticipate that that will align here as well in terms of the prevailing wages being greatly increased should the rulemaking continue and move forward. And then finally, for those of you who do engage F1 student workers, so at the F1 is again a student visa. It's for folks to come to the United States to undertake a full-time education program. Oftentimes, as you might imagine, it's a bachelor's degree program, a master's degree program, although it could be others. We do foresee changes, and some have recently just been announced around F1 students, potentially restricting their ability to work in the U.S., how they go about obtaining work authorization in the U.S., and also how their stay is calculated. What happened is currently happening is that historically F1 students were granted admission to the United States for what's called duration of stay, or D/S, which essentially mean that their I-94 admission record that Kelly referenced earlier didn't have an expiration date. As long as they were in their F1 student program pursuing a full course of study, they could do that ongoing without having to extend their status. Now, at this point, under this new rule, that has changed. And F1 students will now have an expiration date to their status, which also will tie into their work authorization, which will require increased monitoring, also increased applications and timing mechanisms to make sure that they maintain their status and maintain their work authorization. So these are just a few of the changes. Like I said, there was a pretty robust regulatory agenda. Kelly and I could probably talk for an hour to two easily on all of what's proposed. But these are some of the high level changes that we foresee coming in 2026 and beyond. And so, yeah, thank you all. Happy to be able to present and provide these topics to you. I think at this point, we can open it up to Q&A unless we want to go in a different direction.
Yeah, thanks, Kelly and Jason. Really appreciate the presentation. Great information that you guys shared. I'm going to ask the participants to please put your questions in the chat if you haven't already. I see that some people have, and I see Kelly and Jess have already provided answers to a couple of questions, but we do have a few outstanding. The first question is, can you guys share some examples of I-9 violations that occur?
Yeah, great question. So there's a lot of them, unfortunately. I think the most common ones are making sure that that we see is the timeliness, right? Making sure you're getting the employee to complete Section 1 and sign it and date it by the end of their first day of employment for pay, right? So if they start on a Monday, that Section 1 of the I-9 needs to be signed, completed and signed by the employee by the end of day 1, which would be Monday. So that's a big one that I see a lot of employers, can have difficulty with reaching. And then, of course, that day 3 timeline, right? So if they start on Monday, you have until Thursday for them to complete that I-9. So again, then you as the employer making sure you're doing that document verification with them and you're signing and dating it by the end of that 3rd business day. So those are the 2 big things. After that, then it becomes, maybe some errors like you're typing in the number and the number of the document isn't accurate. Maybe the expiration date isn't accurate. Maybe you use the wrong document number, right? We know that some documents have several numbers on them, especially government, USCIS documents. There's the A number, there's the document number, and you're not exactly sure maybe which one you're supposed to be using. So making sure you're using that right document number. So those are all like date of birth. We see sometimes for whatever reason, the employee will put their date of birth in the date that they sign it as opposed to up in Section 1. So really making sure that you're going through those data fields and you're checking for those errors. All of those things are considered errors. And in the past, some of the if it's just the document number is accurate, but you put a 0 versus a 1, that is still considered a technical violation. But if you put the wrong document altogether or the wrong number of that document, that is now considered substantive. So just understand some of those changes.
Thanks, Kelly. Next question is, how do you sign up for alerts on USCIS? And how do employers support individuals that have TPS work authorization about to expire in our current uncertain environment?
Sure, yeah. I just added in the chat a link that where you can sign up for email updates from USCIS. So that's the best place to get those USCIS updates. In terms of supporting TPS, those in TPS, I think for me one of the most important things is kind of recognizing the issue at first. I think oftentimes it's even hard to know who your TPS population is because it's not typically tracked. In our world, when we work with employers and we're managing, let's say, their H-1B program, we're able to run expiration reports. We know who their H-1B workers are because we've assisted them through the process. With TPS, when they onboard, they don't need any assistance or support from an employer. And so actually just even knowing who the population is can be somewhat difficult. So I would say getting your arms around the population is helpful. And then I would also say getting out in front of it as far as you possibly can. Generally speaking, and Kelly chime in, but I think generally speaking, we say, 90 days, 120 days before expirations come up, when a work authorization is going to come up for expiration, to start reaching out to those employees and say, hey, this is coming up. Again, not ask for specific documents, not ask to present anything, but just say, by this expiration date, which is coming up in 3-4 months, we're going to need you to re-verify your work authorization. Please get out in front of that. Oftentimes that will trigger the employee oftentimes to volunteer. I'm in TPS. I have TPS and I'm from Haiti. I understand it's in flux. What should I do? And that's a good opportunity, to start reviewing the notices, get in touch with your advisor or your immigration counsel so that you can start monitoring the issue, monitoring the alerts, and being on top of it. Unfortunately, with TPS, what we've seen is a lot of things that come down to the last minute. Like the day that it expires, a notice comes out and says, oh, nope, now it's extended for 2 weeks. So there has to be a bit of nimbleness, when you have, folks in TPS status.
Thanks, Jason. We do have one other question that came in through the chat. Kelly, I see you've answered it, but just in case people can't see that, could you explain what categories are versus are not allowed to stay and work while their application is pending?
Yeah, and that I put a couple in there, and that is a little bit tricky because most of these are set by policy, not actually in the regulation. And I think that's what makes this area so tricky. So for example, if you're on an actual an employment-based visa, like an H-1B, an L-1, an O-1, you are allowed to stay and continue to work by regulation. So in the regulation, it says if you file your application to extend that status prior to the expiration of your current status, then you're allowed to continue to stay and work for an additional 240 days. Or if it's a change of employer H-1B application, which we call portability, there's like a different, a longer time period. If you're STEM from OPT going to STEM OPT, there's a 180-day extension. But for a lot of the other categories, there are no longer these extensions, right? And so, like, for example, in the chat, I put DACA. Somebody's a DACA worker, they're allowed to remain and stay in the United States, even though their application is pending. So if their current status, has ended, but their application is pending, by policy, they are allowed to stay. They might not be able to work, right? They have to still get that renewed EAD card, but they are allowed to stay. H-4 workers are very similar. So H-4, there's no automatic extension for them, but they are allowed to stay while their application is pending. So, there's these categories to know which ones are allowed by policy and not. So it's majority of them are allowed to stay. They might not be able to work, but most folks, if they have a pending application, they're allowed to stay.
Thanks, Kelly. So I think that does it for our Q&A. Thanks to you and Jason for that. I'm going to turn it back over to Mary now.
Hey, thank you very much. Thank you to all of our incredible presenters, Delegate Boafo, Kamal Essef, Jason Barrett, and Kelly Dinning, and for bringing such thoughtful and practical insights to today's discussion. It's incredibly important for Maryland's employers to understand this. And thank you to all of you who are part of this important conversation. Immigration policy does continue to evolve at the federal level, and these changes have tangible implications for Maryland's workforce and for employers. We value our ongoing partnership with the governor's office and appreciate their support in helping Maryland's business community stay informed and prepared. A recording of this will be sent to all registered participants later this week. Before we sign off, if you are interested in staying engaged on other policy topics affecting Maryland employers, we'd love to have you involved with the Maryland Chamber of Commerce if you aren't already. So go to mdchamber.org if you want some more information. And once again, thank you for joining us, and we look forward to continuing this conversation. Have a great day.